with that, I would like to just add one comment, quoting my good friend Senator Elliott. We are not breaking new ground here. This is something that is passing in several states across the United States, and I would entertain questions.
I'll start with the question. I don't understand how page 30, line 17, how that's not cause problems. Parties mutually contract, and there's a choice of law provision that, let's say, France. We've got a French company here in Little Rock that makes airplanes. If I was an attorney for the French company, I would be very hesitant to sign any contract with an Arkansas resident or company if their choice of law provisions could be stricken or avoided when both parties agree to it.
And Senator, I would be in complete agreement with you if that's indeed what this says. But according to my reading, and in the interest of full disclosure, as a Louisiana lawyer, I kind of look at this with a bit of a civil code eye, so I'm walking with you as far as you're concerned. But there's no, unless the contract that they were attempting to try and pick a choice of law for French courts was something that was inherently in violation of a fundamental principle of Arkansas law, or a fundamental principle of the United States Constitution, allowing for slave labor in the production of goods. I really don't see where an out clause would apply there. This is saying you're allowed to have your choice of law. The only condition is one is a massive violation. The fundamental rights and liberties, privileges granted under the Arkansas Constitution and the United States Constitution. I'm not aware of any company that regularly goes around contracting with major violations of fundamental rights. But perhaps the Senator would be able to educate me on that.
Well, I mean, due process. They may think French due process is perfectly adequate, but an Arkansas court says, no, that's not. In Arkansas, we require 30 days notice. In France, their notice requirements are only 10. Thereby, I'm going to home rule you, French company, and we're going to have this dispute held in Arkansas.
I believe you could currently do that, Senator. I don't think we're going to cross swords with any of your existing law with this particular piece. I understand your point, but I don't think under your current rules and provisions of comity, you would have a creative lawyer could find an opportunity to drag anything before the bench and bar. And
I agree with that, but I think
waiving that, I think that at the end of the day, the fact that somebody could file it, whether or not they could get it ruled on, I don't think this is going to affect that any more than anything that you currently have in place, Senator.
well, if I was a French lawyer, I would say we got to be real careful about contracting with Arkansas companies given this, and Tennessee. That's why I'm curious. I'm surprised.
We have a French company runs the entire commuter system for Orleans Parish, or the city of New Orleans.
No problem.
This law has passed in Louisiana, and it passed 8 years ago. There has been no issue. The equipment that comes in from France. The governing rules of that company and its corporate charter are international. We have not had an issue. I appreciate the concern, Senator, but again, haven't seen the reality of it.
All right, Senator Rice.
Your red hair